Namaste everyone. My name is Pranav and I belong to Faculty of Economics. And in this session, we are going to talk about Roscoe-Pound's jurisprudence. So, what is Roscoe-Pound's jurisprudence? Pound was concerned with the working of law rather than its abstract content and its social purposes and institution within the context of social progress. So, it was mainly law in force. It was with the working of progress. And his attitude was essentially functional. Law, law as distinct from laws, was a system which provided the foundation for judicial and administrative action within an organized society. Theory of interests, which outline which outlines which outlined various wrongs that we will see later on, is based on a belief in necessity of a legal order which demands a classification, securing and protection of those interests. So one of the main aims Pound's jurisprudence is an understanding of the mechanisms appropriate to achieving a balance of the security of society and of each individual's life. The law must attempt to satisfy, reconcile and harmonize conflicting claims and demands so that the interests that weigh most in society are given an appropriate prominence. Now to this end, a process of balancing is needed. So it involves reference to rules, principles, conceptions, and standards. Now let's understand these terms. What is rule? According to Pound, rules are precepts of a detailed nature. Principles are starting points for legal reasoning. Conceptions are categorization of causes and situations. And standards are markers of limits and limits of permissible conduct. So the appropriate balancing process will reflect the aim of law, which Pound spoke of as social engineering, concerned with the ordering of human relations with a minimum of waste and friction. But to secure the society, the greatest number of interests with the least possible sacrifice of other interests is a primary function of the law. Now, Pound defines an interest as a demand or desire which human beings, individually or in group, seek to satisfy and which must be taken into account in the ordering of social relations. Now, the theory of interest recognizes the existence of three types of interests, which defines the limits within which they should be recognized and given effect by law and emphasizes the need of secure them. So, from an inventory and classification interest, decisions on their recognition, significance, and mode of ensuring the security will emerge. The key task for jurists and legislators, that is the balancing of interest. Now, Pound's taxonomy is quite complex and based on division of interest into three basic categories, that is individual, social, and public. Remember, these interests are not created by the law. The law recognizes them and classifies them. The individual interests are interest of personality, or interest in the domestic relations, or interest of substance. They involve claims and demands relates to an individual life. For example, personality, that is physical security, freedom of belief, etc. Domestic relations, interest of parents, children, protection of marriage, etc. Substance, property, freedom of contract. Social interests are wider claims or desires of the group, which constitutes the community. So these includes general security, security of social institutions, general moral standards, conservation of social resources, general progress and individual life. The public interest. Public interest relates to a claim viewed from the standpoint of a politically organized society. So they include interest of the state considered as a juristic person. Now, the interest of the state in its role of guardian and social interest. The ultimate thing is these interests must be balanced fairly, and this can be achieved only by examining a conflict on the appropriate plane or level. One ought not, let's say for example, one ought not to weigh an individual interest against public interest. Further, the satisfaction of as many interests as possible might involve the testing of a claim to a new interest. Pound's solution to the problem of recognizing whether or not a claimed new interest shall classify or qualify for recognition is to consider that interest by reference to the juror postulates of a civilized society. The postulates encapsulate the underlying values of a society. Now, given these postulates, legislators may modify rules and make new ones so as to conform with general values. Now, Pounds has devised something known as jural postulates. Now, Pound's jural postulates may be stated in the form of assumptions. Now, men within a civilized society are entitled to assume that others will commit no intentional aggression upon them, that they may control for beneficial purposes what they have discovered, created, and acquired, that others will act in good faith and carry out promises, that others will act reasonably and prudently and will not impose, by want of care, unreasonable risk of injury, that others will not remain or keep within proper bounds things harmful in their normal course of action. The Pound later added the following postulates that men should be entitled to assume that the burdens that the burden incident to social life shall be borne by society, and that the least standard human life shall be assured to every individual by way of immediate material satisfaction. Now, let's try to summarize this. Let's try to summarize whatever Pound means when he say all of this. The Pound view law functionally as a necessary social institution created to assist in the satisfaction of human wants. The satisfaction of wants necessitates an analysis of interests so that they may be systematized and secured by society's legal institutions. Conflict of interest will demand a process of balancing one against another on the same plane. Where conflicts follows on a request to recognize a new interest, reference is to be made to the jural postulate which reflects society's values. These postulates are not immutable and will require revision from time to time. Now, the criticism of Pound's theory has been intense. It is claimed in general terms that his theory is not an integrated whole because he has failed to synthesize his thought. It is not always possible to see the link between the instrumentalist outlook, which dominates his view of law, and his insistence on the significance of values as the basis of jural postulates. Now, critics suggest that Pound may have derived his purpose of society from principles which are couched in a form of words making factual proof impossible, and that he made no actual advance in our understanding of the law. He has done no more than rationalize the actual. Obviously, his views are said to reflect the thinking peculiar to American society of his day, and may be difficult to translate to another epoch. The theory has been said to be based too closely on the aim of making things work better and to provide little more than a minimalistic picture of social needs, which is not entirely relevant to this day. Now, his methodology involving the articulation, a taxonomy of interests, has been criticized as suffering from the reification inherent in any attempt to classify in systematic form phenomena outside the range of natural sciences, with the result that personal attitudes and subjective perspectives emerge as aspect of objective reality. Now, these criticisms have certainly undermined the credibility of the theory of interests. Now, what we will see that the criticism leveled at the theory of interest may have removed it from the mainstream of modern jurisprudential thought. The very concept of taxonomy of interest, that is over ticketed and over docketed, is considered as a flawed. Little is left of the pretensions of the theory to have explained the significance of social effort in creating a civilized society. But the general outlines of Kant's theory do serve as a continuing reminder of the approach to law as a means to an end and as an enunciation of socially important reconciliating task of law. Now, Friedman had remarked something about him. He said that the theory does not make that the theory does make inarticulate premises articulate and serves to remind legislators and jurists of the need to consider the overall interest of the community when addressing matters relating to the purpose of law within society. With this session has come to an end, and in further sessions, we'll talk about feminist school of thought and little bit about communist school of thought. So we'll meet in the next session.